Hi everyone, it's Holland. Today I'm going to be talking about the Lanterman Developmental Disabilities Act. I have a developmental disability. I was born with Bardet-Biedl syndrome. So I thought this would be a great time to talk about the Lanterman Act. This is from Wikipedia. You can go there. Let me just get situated here. Okay, let's begin. Just get situated. Oh, no. No. There. Sorry about that. Okay. The Lanterman Developmental Disabilities Act, AB 846, known as the Lanterman Act, is a California law initially proposed by Assemblymember Frank D. Lanterman in 1973, passed in 1977, gives the people with developmental disabilities the right to services and supports that enable them to live more independent, normal lives. History. The legislation significantly expanded upon its landmark predecessor, the Lanterman Mental Retardation Services Act, AB 225, initially proposed in 1969. Okay. The original act extended on the state's existing regional center network of services for the developmentally disabled people, which mandating the provision of services that supports that meet both the needs and the choices of each individual. The Lanterman Act declares that persons with developmental disabilities have the same rights and responsibilities guaranteed all other persons by federal law and constitutions and laws, and charges the regional center with advocacy for protection of these rights. In addition to persons with intellectual disability, the regional centers are now mandated to serve persons with cerebral palsy, epilepsy, autism, conditions similar to intellectual disability, or conditions that require treatment to similar treatment required with persons with intellectual disability. To be eligible for services under the Lanterman Act, a person must have a sustainable disability. In 1976, the Lanterman Act was amended to establish the right to treatment and rehabilitation services for persons with developmental disabilities. The Lanterman Act was amended in 1998, which called for an advocacy coordinator to be employed at each of the 21 regional centers of California, therefore making it a law that those employed through the regional center would be prohibited from serving on a regional center board of directors in order to avoid a conflict of interest. In 2003, the definition of sustainable disability was prospectively amended to require the existence of significant functional limitations in 3 or more areas of major life activity. Previously, to have a sustainable disability only required the existence of a significant functional limitation in one of the 7 areas of major life activity. Here are some of the rights under the Act for the disabled. The Lanterman Act protects the rights of people with developmental disabilities by mandating rights, including services to protect liberty provided in least restrictive, most integrated way, dignity, privacy, humane care, treatment services that support in natural community settings to the greatest extent possible, participation in an appropriate program, publicly supported education regardless of degree of disability, prompt medical care and treatment, freedom of religion and conscience, and freedom to practice religion, social interaction and participation in community activities, physical exercise, and recreation, freedom from harm, including unnecessary physical restraints, isolation, excessive medication, and abuse and neglect, freedom from hazardous procedures, choices in one's life, including where and whom one chooses to live, relationships with people in the community, how to spend time, including education, employment, leisure, the pursuit of one's chosen personal future, and the planning and implementation of a plan that fits the needs of the desired individual, the opportunity to make decisions and have information to understand to help them make informed choices. Thank you so much for watching this video. I know it was long, and have a wonderful, blessed day. God bless.